Hey, hey. All right, so just another quick segment here. This still concerns the same ALJ denial that we had in part one, I think. It was a mental health case. The person was denied. I did not represent them. I just reviewed the denial decision at a later date. And here are some of the nuggets that we can learn from. Okay, so again, it was a mental health case. I believe the person was under 50. For what that's relevant for. It's relevant for a lot, but not necessarily for every point we'll be making. So another part of the judge's decision says, quote unquote, and this part is largely canned. We see this a lot. After careful review, the undersigned finds claimant's testimony and the representations made by the claimant and a third party on function reports concerning the intensity, persistence, and limiting effects of the claimant's symptoms are not fully supported in the record. Okay, so you know that's going to be, that is right there. You see that you're looking at a denial, without even having to get to the end. But so notice the language, not fully supported in the record. The record is, I would say the medical record is what they're talking about. So all the things that we talk about, and I say this to my clients a lot, I said, what you and I both know, what you tell me, what I tell you, what I know about you, because most of my clients and I interact quite a bit relative to what people find elsewhere. But what we say is not going to be medical evidence. So the testimony is not medical evidence. The function report statements are not medical evidence. So unless what you are complaining about, you don't somehow really drive it home to your medical providers in a way that is productive, it's not getting into the medical record. Now, it could be that the nature of the impairment with the diagnostics always screams out that these would be the limitations in the severity and the duration and all that, persistence and intensity and all that. But that is often not the case, because sometimes some impairments, many of them, I would say back impairments might be one, run the gamut from mild to extremely severe. And they can look the same even in a diagnostic, but it affects people differently. So you really got to make sure in whatever way you can that your medical providers are not being lazy when they record your complaints at each and every visit. Sometimes we're in and out of there so fast, we're shuffled through, or we're just not in the state of mind to be chatty, and we're dealing with a flu and not really our chronic disabling problems, and we don't do it. I really think we need to do it, because what you say at testimony, if it's not showing up as you having said it to a doctor, if that judge is not, really inclined to award you, that will probably, you'll probably find this paragraph that I'm looking at right now that I just read to you in your denial letter. It's there a lot. So another thing I wanted to bring up about that language, symptoms are not fully supported in the record. That is the newfangled politically correct way of saying he's not credible. A few years back, they decided that that was not a term. Credibility was not a term to be used because it can hurt feelings. So it means the same idea, not fully supported in the record, means they don't necessarily believe you. Now, from a more objective and less snipey way of looking at it, truly, they do have to find it in the medical record. I mean, if we were to have all cases decided on claims alone without it being found in the medical evidence, let's face it, a lot more people would be on disability, and many who are not actually disabled from all jobs. So, there has to be some semblance of objectivity. But make no mistake, not fully supported in the record means that used to be the paragraph where they said he's not entirely credible. But I think it was ticking off a lot of claimants, and it was really rude and insulting. So they smartly got rid of it, politically correct as it may be. Another statement in this very same ALJ denial. And again, remember, this was a mental health case. And we have had discussions before about how with mental health, particularly if that is what one is relying on, particularly if someone is under 50, due to the lack of other rules that can help, one who can get by without inpatient hospitalization will often be seen as being not completely demolished by mental health, and they could do something simple, non-stress, 1, 2-step, third grade type job. All right. So in this case, and I've seen people get very upset by that, and I get it. Like, who wants to be, if you're getting by, but without hospitalizations, no one who wants to go to the psychiatric ward, right? It's, it seems like a scary proposition. Even though oftentimes it works so wonderfully to get someone stabilized who can be restabilized and be a functioning person out in the real world and not subject to living out of their room for the next 3 years. But again, I think it goes back to, and I'm just going to read you the paragraph and then I'll go on more. Quote, there is no evidence of inpatient hospitalization at any time relevant to this decision. Interesting way of saying it. At any time relevant to this decision. He's not saying the person has never been psychiatrically admitted. He's just saying not at any time relevant to this decision. Now, if this decision is covering an alleged onset date, let's say of 2 years ago, to the time of the hearing. So let's say there's that 2-year window that the evidence has to exist as to the severity and the truly fully disabling impairment. Then something that happened 3 years ago, let's say it was a year before she files, this person is inpatient for, I don't know, a couple months, and then gets out, she's stabilized, she goes back to work. And then of course, a year later, it happens again. This judge is apparently, it's suggestive that there was an inpatient, but it fell before the time period in question. Now, true, if it was 10 years before, and I understand if it's 1 year before, and then they worked again, they had a successful work attempt after, so that was not a disabling period. It only lasted 2 months, and there was a 12-month duration. So I understand that itself wouldn't be disabling. However, I don't know why it wouldn't be relevant. I mean, it is historical perspective on the progression, the history of the difficulties that helps establish that they were indeed severe and may still be now. So I don't really like that expression, but that's what this judge decided to do. He also notes, he or she, I don't even know, that at the mental status examinations by the treating provider, and it looks like he's looking at it for about 1.5 years, show that the claimant was oriented to person, place, and time. So if you know who you are, where you are, and what the date is when you go to your MSC, apparently that's evidence of not having a severe problem. Or I'm sure he found her to have a severe impairment, not a disabling severe impairment. He also goes on to say that most of her treatment sessions, there were no abnormalities in her speech, thought process, or thought content. Now, this is sometimes a case where there is none, or sometimes providers are just very sloppy and lazy, and they put within normal limits for everything, all those check boxes on their little mental status exams. I mean, the person could be disheveled and not have showered in 3 weeks, and there's nothing there suggesting that that's the case. So it really depends on the quality of the medical provider and their competency. But this judge notes that there's no abnormalities in her speech, except a few of her treatment sessions that showed mild signs of paranoia. Paranoia, that's a pretty big deal. I think even a mild sign, because everyone's on their best behavior when they're at their provider appointment, right? Imagine what her paranoia is when she's not on display in front of her provider. You know what I mean? Like when she's free to express herself or feel it and not, try to act like, a little more in control than she may be. So So this is just the kind of ways they cherry pick, guys. You just have to realize that it is going to be a cherry picking process. So you want to make sure there's as few cherries to pick for a denial as possible. And that's where I come in with all those little, if you're going to talk about this, make sure you spell out this, and he found that she was, so where everything was mild, and that'll never get you disability. He finds that it increases up to moderate when it comes to social and occupational functioning. Moderate, so is more than mild, but less than marked or extreme. It will not generally get a person to be at a substantial loss of the ability to do one of the major areas that we have to do for any job. So that if we are at a substantial loss in any of these major 4 areas, we truly are disabled and will not be able to sustain a full-time job of any kind, even the most simple 3rd grade low stress job. So he's putting things at moderate and mild, because if he steps it up to marked or extreme, he's teetering on a requirement that he awards. So, and the last part I want to mention in this particular video is he got some of that right from, guess what? The treating psychiatrist, who apparently was kind enough to complete a medical source statement for the claimant. But here, and I have a video on this, how to be careful what you wish for when you're asking your very cooperative and caring provider for a medical source statement. Some of you might refer to it as an RFC. Be careful what you wish for. When they describe your limitations and they think it's important and limiting, and they don't think you could hold down a full-time job, their descriptions, because they don't really understand where the law says someone could work or not, where the vocational rules kick in, because they're not vocational experts. They often say what they say when they think it's disabling, it's not disabling. So in this case, this treating psychiatrist described her as only mildly limited in terms of her ability to understand, remember, and carry out simple instructions. Okay, well, if she's only mildly limited, that means she can do a simple, unskilled job, at least in that aspect. He also said mildly limited in terms of her ability to interact appropriately with the public. We talked about this in part number 1. I believe we did, when the judge also relied on the fact that she hangs out with her family on a regular basis. So that implies to him anyway, that any limitation to interacting properly with the public would be only mild, and therefore, as long as it's not done, perhaps every minute of every workday, should be fine. He describes that the psychiatrist gave the opinion that she is only moderately limited in terms of her ability to make judgments on simple work-related decisions. Again, remember that word moderate. That's more than mild. The psychiatrist is probably like, she's pretty moderately limited in that. But for the SSA and with their definitions, that's not marked or extreme, therefore. So, you know what I'm saying? Like the doctor might very well be thinking, this is very bad. It's moderate. Not severe where I got to commit her, but moderate, which is way more than mild. And mild is more than non-existent. So this is where a doctor just filling out a form when he doesn't know what the words mean. I want to say more often than not, it's going to hurt you. Maybe more so in the mental health aspect, but I would say it's often true on the physical also. I think the doctor needs to be educated. And of course, there are little guides that can do that, in a page. At least they have the definitions of what these things mean, so they can properly use the right language when they're describing something. Their industry terms are not the same as the SSAs. And he also said she's moderately limited in the ability to interact appropriately with coworkers and supervisors. I think we mentioned in part 1, I think. Well, there are jobs you don't need to deal with the public at all. And there are jobs that you don't really have to deal with coworkers. But I believe all occupations require that someone can at least occasionally interact with their supervisor. So if she's moderately impaired with that, but not marked or extreme, then I think the presumption or the crossover is that then she can at least occasionally interact properly with supervisors. And what would that mean? That means not crying as soon as they constructively criticize you, not being argumentative if you're told to do something, that kind of thing. The funny thing is, and I don't know if I mentioned it in part one, but when they say a person can occasionally do that, and that's all they need to do to hold this pretty simple job, and therefore they can do the job and are not disabled, occasionally, that's up to 1/3 of a day. It can be as little as next to nothing, but it can go up to 1/3 of a day. One thing I always bring up on cross is, can a employee pick and choose what specific times a day that supervisor may come and interact with him? If you can only do it occasionally, that's 1/3 of the day. That means or up to 1/3 of a day. That means 2/3 of the day or more, he cannot reliably interact with the supervisor. So does the supervisor have to wait in his little cubby hole and say, "Can I come interact with you now, little employee?" I mean, this is not something that's going to happen in the real world, right? And you can kind of get a vocational expert to acknowledge that. I've never seen a vocational expert, when I brought it up, say that the employee gets to make the rules on when they interact with the supervisor. Can you imagine? I mean, it would be a blatant untruth. So anyway, that's just another funny thing about that occasional, if they're can occasionally interact appropriately with their supervisor, what about all the other 2/3 of the day? I mean, the supervisor needs to talk to them. Ooh, there we go. Everything goes out the window. Anyway, these were all the things that the judge, well, this is part 2 of this one. I don't know if there's any more with this particular ALJ decision, but I gave you 3 big bad ones, I believe, in the part 1, and same decision, another 3, which were really more about how the judge then went and interpreted things and used them for the denial. So I hope this gives you a little insight. We'll get through more if it happens to be helpful to you. You know, I think part 1 is helpful because those questions involved what you say on your function report and how the judge can use it against you later. All right. Bye, guys. Have a great rest of your day.